All right, good morning, everybody. Welcome to an oral argument session at the 5th District Court of Appeal. My name is Dan Traver. We are being streamed live on YouTube today, and this is being recorded. I'd like to introduce you to the rest of the panel. I'm joined this morning by my colleague, Judge Eric Eisnagel. And we're also happy this morning to be joined by an associate judge, Judge Carol Falvey, who presides in the 5th Judicial Circuit. Welcome, Judge Falvey.
Thank you.
We have two cases on our docket this morning, and this is the first. It's case number 20-610, David Klug versus the state of Florida. Mr. Berry, I'm going to assume that unless you tell me differently, that you'd like to reserve 5 minutes for rebuttal. And you may proceed at your convenience, sir.
Your Honor, thank you. May it please the court, you read my mind. I was going to reserve 5 because it usually ends up at 2, and so we'll see how it goes. As you indicated, my name is Robert Berry. I'm the attorney for Mr. Klug here at oral argument today. I had intended initially to take the issue sequentially, but I'm going to divert that a little bit. I'm going to start with issue 2 because under the Gonzalez decision, the this court's interposed a good faith analysis on the requirement under 3.140G that the state have sworn testimony in some form, whether it's directly to the state attorney or through a police officer witness or through some other sworn format, but that there's a good faith analysis that sort of supersedes the express language of 3.140G. And the reason I'm starting with that is because the decision that led to count 4 being added on the day, literally on the day of trial, also has some relevance to the addition of some language to the first 3 counts also on the day of trial in the third amended charging document, the 4th iteration of a charging document in this case. I'm going to go through the facts really quickly that are relevant to the good faith issue, and we can sort of proceed from there. The client was arrested in April of 2014. About a month later, the state files a charging document around May 20th. About 5 days later, they basically do some corrections and the kind of things they would normally do to clean up a charging document. And then for reasons that aren't relevant here, the case sits in, a litigation status all the way to the point where it's put on a trial docket in December of 2019. The state asked for continuance of that case on that docket. Judge Crawford, not the Marshall Crawford, who I guess is keeping our time here today, but Judge Charles Crawford kept the case on a docket despite a state motion to continue. Trial doesn't happen in December, and so we get to this basically time certain trial for January 13th, which is a Monday back in 2020. On the Friday before trial, after the close of business at 5:30, the state decides to file a Williams Rule notice. Now, first of all, keep in mind that Williams Rule requires 10-day notice, so they're by definition tardy with their Williams Rule notice. In that notice has one thing that's actually 2 things that are really critical to the good faith analysis, and the things we're going to talk about with the first issue as well. They allege in the 5:30 p.m. notice on the Friday before trial that they wish to introduce Williams Rule evidence that my client had allegedly attempted to force or entice the alleged victim to touch his penis. They don't allege that he actually did it, but they allege he tried to force or entice her to do so. And furthermore, they allege a time period that encompasses counts 2 and 3, which is essentially December 26th of 2013 through February 2nd of 2014. April 11th of 2014. That's the critical point. they allege a period from December through April. The next day at 8:30 p.m., oh, I'm sorry, going back to that one. With that notice, there is no notice of any new statements by the alleged victim, any Brady material, which would be contradictory statements, because this is new assertion of fact by the state. On Saturday night, the Saturday before trial at 8:30 or 8:32 p.m., they file a second Williams Rule notice, an amended one that now says, again, the same time period, December 26th through April 11th, and allege that Mr. Klug now has succeeded in enticing or forcing the alleged victim to touch his penis. Again, no new discovery supplied to the defense, no Brady material notices or anything like that. And then we get to, and obviously this provoked a motion to strike by the defense, not surprisingly. Furthermore, not surprisingly, when it was heard in front of Judge Crawford on the Monday of trial, he struck their Williams Rule notice because, among other things, it's untimely. The state then files a second amended charging document, the third iteration of a charging document in the case. In this one, they do not allege on one or more occasions as to counts 1 through 3. They allege a single act in count 1, count 2, count 3. They then in count 4 allege now for the first time that my client enticed or forced the alleged victim to touch his penis, not between December 26th and April 11th, but they've somehow now shortened the time period from December 26th through February 2nd of 2014. Again, no notice of new statements by the defendant, by the alleged victim, no new Brady material or anything that would suggest that what happened between Saturday night and Monday morning that would provoke a further narrowing now of this time period. And then they follow that up before the defense could even file a motion to dismiss that second amended information. The state files a third amended information at about 11:30 that morning, about an hour or so after the second amended information. And in that one, they've added in the on one or more occasion language to counts 1, 2, and 3, not to count 4. They leave that the same. And this is clearly, I see no other way to look at it, as this is the state's attempt to get around the Williams ruling or provoke a continuance by the defendant so they can then file a timely notice of Williams ruling and solve the problem that they've created for themselves. One thing I don't know if I added about the December trial docket that they were on, I can't remember if I said this or not, and stop me if I said it, but the case was set on a December trial docket. The state moved for a continuance. It was denied. At that point in time, in December 2019, they don't notice of Williams rule. They don't notice the court of any intent to offer any Williams rule evidence. They wait literally to the Friday night before trial before they start trying to put in Williams rule evidence. And the whole amendment of the charging document twice on the day of trial, an hour before the jury, actually the jury's waiting while they're doing this, is evidence as to issue 2 of bad faith as to count 4. There's, under the Gonzalez case, there's, I guess, 2 components. One is bad faith, but that's sort of the second thing that the court looks at, as I understand this court's ruling. The other thing is there a sworn basis? And there is not a sworn basis in the record. And the easiest way really for the state to have addressed this would be to say, if they had actually done it, is, Judge, we can solve Mr. Eisenmaker, the trial attorney's confusion about how we came to file this new charge we talked to the victim who's in town for the trial over the weekend or that Monday morning, put her under oath and said, did this happen or something like this happen? If so, when? Oh, it happened on this day between this time period, and that's how we did it. I took a sworn statement. They never said that. They don't say.
Counsel, does that make it patently false because they never clarified? I guess I'm just having a hard time following the dots you're connecting.
The dots I'm connecting, Your Honor, are that they saw problems with their case as charged. They attempted to get Williams rule evidence in. They failed. And this new allegation of a time period that somehow shrinks from Friday night and Saturday night, changes in the nature of the allegation and in the time period with when it happened. I mean, Friday night, there is no touching of the penis, but it's between December and April. Saturday night, they're now saying she did touch his penis between December and April. Monday, they're now saying she touched his
Friday,
penis
they
between December and February 2nd.
Counsel, on Friday they affirmatively said he did not, and then on Monday they affirmatively said he did, or are you sort of adding some stuff in there?
Let's see, Friday notice. This is at the record at. It's printed over. Looks like 682.
I'm just asking if they initially affirmatively represented that he did not.
No, sir. They don't put in their notice that he did not do that.
So that's your sort of. You're extrapolating that, right? I mean, essentially, do you agree?
I don't think I'm extrapolating when they say, I guess in the technical semantic sense, strictly, I am extrapolating that when they don't say that she touched it, especially when you compare it against Saturday night's change where they say she did, I guess I am.
Counsel, I think, isn't there a difference between a patently false statement and a statement that draws legitimate questions? I mean, I think perhaps you are raising legitimate questions about it, but is that the same thing as a patently false statement?
Let me correct if I've given a misimpression. I don't want to do that, and I start with the place where I don't make accusations of bad faith lightly. I'm not saying that. I'm not saying that they are affirmatively stating on Friday at 5:30 that this last business day before trial that they are asserting she didn't touch his penis. What I'm saying is that they have one version of events in their Williams rule notice on Friday. They have the difference between not touching an adult's penis and touching it is a substantial difference because it becomes a much more serious crime. And so between Friday and Saturday night, they have changed the terms of their accusation. I don't really care whether Friday is false or not. For my purposes, I'm saying the nature of the allegation changes. It's adopted now in a charging document on Monday when they don't get the Williams rule evidence past the notice requirement, and they shorten the time period. Those are the problems.
Those raise.
Go ahead.
Those seem to raise legitimate questions that you could ask, I think. But in your brief, you say the legal question for this court to resolve is whether the state's patently false sworn assertion that initiated a prosecution against a citizen of this state's merits dismissal.
I'm still looking for the patently false.
Hadn't gotten there yet. I'll get there
Okay.
now.
Could you go ahead and get there?
I was about to when we started this interaction. The patently false statement is that the state is asserting that they have sworn testimony that between December 26th of 2013 and February 2nd of 2014, specifically within that time period, the defendant enticed or forced the alleged victim into touching his penis, as alleged in count 4. They don't have that. Their best argument in their
I looked
brief,
at counsel. I looked at your record sites, and I just don't see how your record sites prove definitively that the state's sworn assertion is false. Can you walk us through that part? How is it how do you know that it's patently false? I did look at the citations to the record you provided in your brief, and I'm still not seeing it.
they allege their best day in court, as they allege in their motion, or I'm sorry, their response, and their response to Judge Crawford, which is very brief, is to say, we put two things together. We put the deposition that's taken by Mr. Eisenmenger prior to trial, where she for the first time says, I touched his penis. Doesn't put down any time or anything like that. They then, I'll give you that that's under oath. But there's no time assigned to it. And Judge Crawford, if you read the record, not far after the section I'm referring to, says the issue is the time. Because what the state tries to do, instead of simply asking the alleged victim and to get a sworn basis, they argue to the court that the CPT interview where she says, well, there was an incident in the bathroom that she alleges to have occurred between or the state alleges between December 26th and February 2nd occurred not tied to the touching of the penis and not tied, and the CPT interview is not a sworn statement. And that's the state's argument. They have an unsworn statement that they are tying to a sworn statement, and they in their minds are associating the two without ever talking to the alleged victim about this. And so there is not a sworn basis. So on the binary question of is there a completely sworn basis for this allegation, the answer is no, by their own version of events. And secondly, the Williams rule problem creates the bad faith. And I'm happy to answer other questions, but now I'm down to 303, 02, 01, 00. So if y'all have other questions about that, I'm happy to answer them.
We'll reserve the rest of your time for rebuttal. Ms. Davenport, good morning. You may proceed.
May it please the court, my name is Chris Davenport and I represent the state of Florida. This issue is, there's a lot of deference paid to charging decisions by the state, as there should be, given the separation of powers, and this is the executive branch. The question is whether the prosecutor acted in good faith, not whether the evidence is substantial enough. That's from this court's decision in Gonzalez. Unless the evidence is so lacking that a reasonable prosecutor cannot be said to have acted in good faith, you have to reject this type of challenge to the information. Prosecutor explained that this touching the penis allegation came up in the victim's sworn deposition. When you look at this victim, especially when you look at the child protection team interview, she's very, very reluctant to talk about this. She's embarrassed, she's shy. She had a really hard time discussing this with a stranger, as a lot of children do. She made this allegation in the deposition, sworn testimony. In her child protection team interview, she had explained that there was a bathroom incident. This happened in the bathroom. The state put 2 and 2 together and said, this is the time frame when it happened. This is she's giving more details about the bathroom incident. There's nothing bad faith about that. There's nothing that can be second guessed by the judicial branch for the state taking this allegation made by their victim and adding a count. The Williams rule notice was late. It was stricken by the judge. That's what's supposed to happen. That doesn't show bad faith in bringing a charge that the victim testified to under oath in a deposition. So this claim has no merit. Unless the court has questions, since this is the only issue he raised, the state will rely on its brief as to the other issues unless the court has.
I'm curious about the first argument they make. Charging a crime and then saying that it occurred on one or more occasions within a certain time period. What do you think of the 4th District's opinion? I think it's in Smith, isn't that right? Isn't it Smith versus State, right? 4th District?
Mm-hmm. Judge, I think that the issue in Smith was very different from the issue here, although they certainly charged one or more occasions in both cases. There are many cases from the 4th DCA saying that you can charge one or more occasions, and from all the other districts. You can charge this because it's just as a practical reality. These victims are young, they have a hard time differentiating between events, they have a hard time with dates. So recognizing that and recognizing the state's strong interest in prosecuting this type of crime, the courts have uniformly held that you can charge on one or more occasions. In fact, in Cooper, the court said you could have solved this problem by charging on one or more occasions. It's a suggested way to charge. And the theory behind that is that in these circumstances where you have a victim who says it happened over and over, but they can't give dates and they can't give specifics about each incident, this is the way to charge it. That's what the state did here. That's entirely appropriate. In Smith, the caveat to that is when you can break it down, you have to do that. Right. In Smith, they could have broken it down, and there's. I mean,
counsel, you agree that this would be more problematic if within the same time frame and within the same count, there was evidence that, well, something happened this way, and then a completely different thing, but it's also a criminal act, happened this other way in this other location. And then you say to the jury, okay, that's count one. That would be a problem, correct?
That would be a problem. That would be more like what happened in Smith, because in Smith, they charged numerous unspecified lewd acts in a 30-month time frame. And again, the caveat to this one or more occasions method of charging is if you can break it down, you have to. That's what the state did here. We have 2 counts with the same time frame, and the touching the vagina and the victim touching his penis. They broke that into 2 counts. If they had put that in 1 count, I think that would have been a Smith problem because they could have broken it down more. In
fact, even Smith even says from the evidence at trial, it is apparent that the charge could have been narrowed both as to time frame and the nature of the act.
Exactly, Your Honor. That's the big problem in Smith, and that's where you run into the unanimous verdict of prodrome and all that.
We don't. I mean, from my reading of the record, that's not what we have here.
That is not what we have here. What we have is, a continuous sexual abuse. They broke it down as best they could by the time frames that the victim could identify and by the type of acts. I mean, it was generally the same act, touching her vagina. And then we also have this, she was forced to touch his penis once, and they broke that out into a separate account, which is what Smith requires and the Supreme Court requires. They can't just charge he committed a bunch of lewd acts over 10 years. I mean, that's where you get a problem. They broke this down as best they possibly could, given how the victim remembered this in her young age. And I would say the courts have uniformly said this is a proper way to charge that in these type of cases. So Smith is very distinguishable, and we would submit that there wasn't a unanimous verdict here, and the state charged this as best it could, recognizing the reality of child sex abuse cases. If the court has no other questions, we would ask you to affirm.
Ms. Davenport, I just have one follow-up. As I understand it, it's your position that breaking out count 4 is illustrative of good faith, rather than bad faith upon the state. Could you?
Exactly.
Mhm.
I think you're exactly right, Your Honor. If they had charged it together, I think we would have more of a Smith problem, because if they can break it out, they have to, and that's what they did here. Granted, it was a last-minute addition. That happens. There's no bad faith by adding in charges that a victim has given sworn testimony in support of. So it's that showed that the state was trying to charge this as enumerated as they could, given the circumstances here. If there are no other questions, thank you.
Mr. Berry, you have a little less than 3 minutes, sir.
Thank you. I'm going to talk about, first of all, this argument that the on one or more occasions is innocuous. Here's how the state should have been required to prosecute this case. Count 1 deals with an allegation that a sleepover, he sneaks into her room and touches her. Count 2 deals with a incident that allegedly happens in a bathroom. Count 3 alleges according to the state in their arguments to Judge Crawford, I'm speaking of, Count 3 alleges an incident where she rides over on her bike in the afternoon and Mr. Klug happens to be the only person there. There's no need for the on one or more occasions. They can limit their time frame. The Delorfrano, I'm probably mispronouncing it, says that because kids are young and their memories aren't good, we allow larger charging document periods. That has nothing to do with this, and the state's trying to convolute this into that issue. It's not the problem here. The problem is they have a specific theory that happened between August and December, between December and February, and between February and April. The on one or more occasions is the way to get their Williams rule evidence in. They didn't have to say on one or more occasions to charge this properly, because they supposedly, based on what they told the judge, had a specific idea of which the incident they're talking about for the first count, the second count, and the third count. But what did they do at the end of each section of their examination of this witness on counts 1, 2, or 3? Did this happen on one or more occasions? Yes. And Ben, let's talk about count 2 in particular, because this is the best example of the problem with this. the bathroom incident, or incidents based on how you read her testimony. She says, in response to the follow-up question, did this happen on one or more occasions? Well, not this, but the other stuff, referring to what she had testified to in count 1. So you do have clearly, I'm just using this as a pretty easy example, but it works for all three. An example of, okay, well, a jury could say, I don't believe that she's describing this bathroom incident accurately, but I do believe they proved beyond a reasonable doubt that he touched her at some point, like he's talking on count 1. And there's spillover for all of these things, as opposed to charging discrete incidents, which is, the Smith decision talks about how you can the penalty for getting what I'm asking for and what Mr. Asimir was asking for is that you may get more charges, but that's the price that we were happy to pay. And I say I got 3 seconds left, and that's regretful. I would have loved to talk more about this, but thank you for your time.
Thank you both for your argument and your briefing. We are going to be